Okay, good afternoon, everybody. We're going to call the meeting to order, start with a roll call. Will the other commissioners who are present please state their names?
Darcy Rourke.
Barbara Baskerville.
All right, and I'm Adam Murray. All three commissioners are present and accounted for, so we have a quorum today. The first order of business is our open public comment period. Do we have any members of the public who are interested in commenting today?
I do have right now one caller online. If you could please state your name, then go ahead with your comment. It looks like you're unmuted on my end, but we can't hear you yet.
All right. Can you hear me?
There we go.
Sorry about that. This is Rob Anderson, and what I was saying is that I know that this is kind of a learning curve process where, it's the first couple of complaints reviewed and looking at all the procedures, and I just wanted to get some feedback. I'm kind of waiting to get my response and kind of digest everything. I don't want to be quick. Obviously, I'm disappointed in the initial decision, but kind of waiting to get all the info and just kind of process it. But what I would request and hope that you would consider is, I understand that the conversations and whatnot are have executive privilege, but there's really no reason why the HR, and maybe it's going to be included in the letter sent to me or people who file a complaint, but there's really no reason why the HR determination or memo, whatever conclusion that they've come to, clearly that was a significant factor or can be a significant factor, and in complaints that are dismissed in particular, I would ask that this commission release the HR director's report or determination, whatever you want to label it, for transparency. That is supposed to be one of the big priorities and end goals is integrity and transparency. And there's really no reason besides wanting to keep the public from the inner workings, because from a perception, I'll just give you feedback, from a perception, it looks like that the county, put the kibosh on complaints against county people behind closed doors. And then came out, and I don't know if the decisions of the commissioners reflect that determination and just followed in lockstep or were independent. And so just from my perspective, and I hope that your goal is to have, transparency and of the highest integrity and ethics standards, I would ask that this process reflect that as well. So today's meeting, I hope that you add to the agenda to release the HR determination, in particular with complaints that have been dismissed. Thank you.
Okay, thank you. And it looks like that is all for public comment.
Okay, Darcy or Barbara, do either of you guys want to respond to Mr. Anderson's comments right now?
I guess I'm a bit confused because I don't recall seeing any HR determination. I see HR has received something, forwarded it to us, but there's been no conclusions that I've read. Maybe I missed what Mr. Anderson was talking about.
I think what he's talking about is probably the HR director's initial determination as kind of in a letter form, I guess. I think what I'd say is that we are independent of the county, and the information that the county gives us is, their perspective on what the complaint suggests and contains, and I wasn't swayed by it in any particular way. I still did my own independent review of the complaint and the facts, and I do think that our business process involves sending a conclusion memo from the county to the complainant if we make a determination that the allegations don't constitute an ethics violation. So I think we have yet to see what those communications will look like. But the information that we review in executive session is appropriate under RCW 4230-110. I know that Darcy and Barbara and I have talked a lot in these meetings about how we all value the transparency of this. And so we're working to be as transparent as we can.
I would agree with that. I believe that all of us did our own thorough reading of the documents that were provided to us and had a good discussion about the issues. So I believe it was totally in compliance with the business process.
Okay, so unless there are more public comments, then the next order of business is to review the submitted complaints. We have 2 that we're looking at today. And so we can now go into executive session under 4230-110. And I think we have slated 15 minutes today. If we need longer, then we'll make that known.
I just want to be clear. I did write to Kristen, but I do X out of here and then into the executive, right? Am I doing it right?
Correct.
Okay, thank you.
And I would like to
Yes.
note, if I could please, that Jessica Skeleton of the Pacific Law Group will be advising you again today and speaking with you in executive session rather than the prosecuting attorney's office.
Very good.
Thank
All
you.
right. We'll look forward to seeing everyone in the other room and then back here when we return.
Hello, executive session is being extended for 15 more minutes, and they will now be returning at 1:40. Thank you. Hello, executive session is being extended for another 5 minutes, and they now will be returning at 1:45.
Okay, thanks everybody. Sorry for the delay. I had to do a restart to get my whole system up and running here. We're back from the executive session and we'll go into deliberations about the 2 complaints we're considering today. So I'm going to start off by kind of explaining my views of the first complaint, Angus Lee complaint against Auditor Greg Kimsey. This is about a 2022 challenge to John Lay's voter registration, and the complaint alleges that Auditor Kimsey helped initiate the challenge and advised opponents on how to construct their case, and that doing so and not disclosing it to Lay constituted an ethics violation under several different rules. We appreciate the specificity in the complaint. There were text messages submitted that allegedly show that Auditor Kimsey was advising someone named Kathy of how to establish residency. Auditor Kimsey then later presided over the challenge to Lay's voter registration on June 28th, 2022, oversaw the hearing and cross-examined Lay. As I read this complaint, a lot of it hinges on these communications that the complaint characterized as ex parte communications. And the trouble that I have with that characterization is that ex parte communications, as defined in RCW 42.36.060, that those rules apply during the pendency of quasi-judicial proceedings. And so no communication from before the filing of the residency challenge would even be an ex parte communications, an ex parte communication. So those communications are prohibited only if the communication occurs while the proceeding is pending. And in this case, I don't see that happened from the complaint. The complaint also mentions RCW 36080 saying that it obligated a full disclosure, but I'm assuming that was maybe a typo and that meant 060 because 080 requires raising an appearance of fairness challenge as soon as possible. And so I'm thinking that was a typo, or at any rate, that statute doesn't seem to say to me what the complaint says that it says. The complaint also says that Auditor Kimsey had a personal interest prohibited under RCW 42.52.020, and the evidence is the 2 text messages that were submitted. And I just find those communications to be too tenuous to establish a personal interest that conflicts with Auditor Kimsey's official duties. It isn't clear to me that Auditor Kimsey expressed any personal interest except an interest in accurate residency information. So I find a similar problem with the allegations under Clark County HR Policy 13.1. I think I agree with the complainant that perhaps it would have been best for Auditor Kimsey to disclose those text communications, but since those communications themselves don't violate the ethics rules, I don't think they can form the basis for ordering an investigation either. So I think if those communications took place while the proceeding was pending, we would probably, in my view anyway, be having a pretty different discussion about this complaint. So that's my statement on this one. Darcy or Barbara, do you guys have anything to add?
It's my understanding that the auditor has the obligation to provide information to other constituents who may be challenging a voter registration. And from the text, that looks like what it was to me. I believe I read somewhere here too that the auditor did offer to recuse himself to the participants before the proceedings started. And then that was not necessary, apparently, from any of the participants. So I think they certainly had the knowledge beforehand that he had other communications, which were part of his job. So I don't see a basis for an ethics violation here, further investigation.
I concur with the comments from both my colleagues. I believe the auditor was doing his job in responding to those questions.
Okay, if there's not more discussion to be had, then is there a motion?
I would go ahead,
Go
Dorothy.
All right. I move that the allegations do not constitute an ethics violation.
Second.
Okay, those in favor of the motion, say aye.
Aye.
Okay, unanimous vote, so the motion is carried. We'll move on now to the complaint from Mr. Anderson against a couple of the prosecuting attorneys. And I want to start out by saying that, this one feels like a close call, and it took a lot of time to kind of parse out some of the different timelines and what exactly happened here, at least as stated in the complaint. So here's my understanding. According to the complaint, county initiative was filed on December 19th, 2023. The prosecuting attorney's office forwarded the battle title to the auditor apparently around January 9th, or at least sometime after the proponent filed for a writ of mandamus about this issue in Skamania County. The violation that's alleged is that the prosecuting attorney's office failed to forward the ballot title to the auditor within 10 business days, and that failure violated numerous ethics rules because it was a willful, knowing, and intentional departure from the initiative procedures that included intentional misrepresentations designed to prevent the initiative from reaching the voters. So this is based on Home Rule Charter Section 7.2, and I think the structure of that section is very important here. So I just kind of want to walk through how I read that that rule, because it's complicated and not particularly clear. The preamble reserves the power of initiative to the people and provides that an ordinance or an amendment to an ordinance, except as limited by state or federal law or court interpretation, may be proposed by filing an initiative. And then it lists some specific limitations on initiatives, followed by a requirement that initiatives that depend on new revenue recommend a revenue source. Then it goes on to section 7.2C, which lists the procedures that form the basis of this complaint. So that's 10 business days things. So the first section of that is that within 10 business days of the filing date, the prosecuting attorney shall formulate a ballot title. So I note that this provision does not state what the prosecuting attorney is supposed to do with that information or when. That doesn't come until the next section. The next section starts out saying that the prosecuting attorneys shall transmit the initiative petition back to the auditor, who has an additional 5 business days to confer with the petitioner. And then the prosecuting attorney has another 10 days to provide the petitioner and the auditor with an opinion about whether the initiative is within the scope of local initiative procedures. So this section, section 7.2, is unclear about how or when the county is meant to give effect to the preamble portion that limits initiative subjects to those not already limited by state or federal law or a court interpretation. In this case, with this complaint, the prosecuting attorneys took that on by informing the petitioner that the initiative would amend the state or federal law and cannot proceed, and later that it violated the one subject rule, before reaching the procedural steps of section 7.2C. The complaint doesn't provide evidence that the prosecuting attorney did that for an improper purpose, in my view. To me, it seems reasonable to interpret the preamble of section 7.2 as providing that the county need not necessarily reach 7.2C if the initiative proposes an ordinance that's already limited by state or federal law or a court interpretation. It's also not clear that the process that the county followed for this initiative resulted in anything different from the process that the complaint asked for. So, keeping in mind that the timeline played out over Christmas, New Year's, and the Martin Luther King Jr. holidays, 10 business days from the filing date was January 4th, 2024. The auditor's additional 5 business days expired on January 11th of 2024. And then the prosecuting attorney's 10 days, and I note that that portion of the home rule it says days and not business days there, so we're not clear which one would apply. But that would have expired around January 22nd to 26th, depending on whether you count the days or the business days and whether Martin Luther King Jr. Day is considered a business day for the county or not. And I don't know the answer to that question. The complaint says that on January 9th, the prosecuting attorney told the initiative proponent that they would forward the ballot title. So presumably that happened forthwith, although we don't have that information. But had the prosecuting attorneys forwarded the ballot title within 10 business days of receipt, it would have happened around 3 or so business days earlier than it apparently ended up happening. nothing in the complaint indicates that the prosecuting attorney's actions prevented the initiative from moving forward. In my view, an ethics violation is its own harm. And to me, I don't think we need to see a harm outside of an ethics violation in order to have an investigation or to find an ethics violation occurred. But I do think that the lack of clarity in Home Rule Section 7.2, the absence of an indication that the prosecuting attorneys acted with bad intentions, and the fact that it's not clear that there was any actual effect on this particular initiative, I think it makes it that much more difficult to conclude that sufficient cause exists for an ethics investigation. So for those reasons, I won't be voting today to order that an investigation happen on this complaint. Barbara, Darcy, do you guys have comments you'd like to make?
Yes, I would like to also point out that the initiative process that the complainant has forwarded the information to us. It says within 10 business days of the filing date, I assume that's a filing of the proposed initiative, the prosecuting attorney shall formulate a true and impartial ballot posed as a positive question not to exceed 50 words. It does not, as the complainant points out later, require him to, the attorney to forward that to the auditor within those 10 days. In fact, there is no guidelines as to when that is forwarded from the attorney's office to the auditor. It says he shall give it a title within those 10 days, and then it just talks about the auditor's 5-day limitations and 10-day limitations, but not, I mean, whether the attorney forwards it to the auditor the next day, the next week, or the next month is not specified here. So there's no violation that he didn't, the prosecuting attorney didn't forward it. And I seem to read the second letter from the prosecuting attorney as setting out several reasons why this may conflict with state or federal election law. So I did not find it quite as close as Adam did, but you read things differently than I do, because I don't believe the initiative has even been, I don't want to say breached, but violated in any way. So I don't see any reason for an ethics review in this case.
I just would say again, I appreciate the very thorough comments of both of my colleagues. We did have quite a discussion about this issue, and it wasn't real clear, it wasn't easy. But I also, upon the conclusion of our discussion, agree that I would not forward this on as an ethics complaint for investigation.
All right, so is there a motion on this complaint?
Go ahead, Darcy, you did good.
All right, I can do it. All right, I would like to move that the allegations do not constitute an ethics violation.
Second.
Okay, those in favor of the motion, say aye.
Aye.
Aye. Okay, so with the unanimous conclusion, the motion's carried. And I realize it's going to be disappointing, Mr. Anderson. I assume that you're still listening, and I just hope that you trust that we are reviewing these carefully and independently, and you're always welcome here. So that concludes our business for the day. Well, first, I guess, is there anything else for the good of the order? We are on the fast track here of trying to get through our backlog of complaints. Our next meeting is Friday, June 21st at 10 a.m. So look forward to seeing everybody then, and we'll carry on. With that, we can adjourn.
Thank you.
Thank you.
Thanks, everybody.